with the Wake Tech Small Business Entrepreneurship and Small Business Center. Let me turn my camera off. This is us. Lori Wright, the brains behind the operations, is here as well. My counterparts, Chris Weeks and Dave Geikler, run our launch programs. If you're familiar with this, straight up our website. They run the launch Wake County program. So if you're in any municipalities virtually, there's a launch program for you. It's a great 10-week cohort-based program that runs with our semesters. I know Launch Raleigh and a couple of the other ones are wrapping up as we speak. And then come January, there will be a new iteration for places like Cary, Morrisville, a couple of the others. So if you're interested, take a look at the website at sbc.waketech.edu for them. But the Small Business Center Network is unique in that we're at all the community colleges throughout the state. You can take advantage of us at every single community college. So just within about a half hour's drive of our location, you can hit Durham Tech, Vance Granville, Central Carolina, even Johnston County. Heck, you're not even too far from our counterparts over there in Wilson, where our presenter is from today. There's the map so you can see what I'm talking about. And of course, we're here to help you start or grow your business. And today it's unique because one of our highest clienteles is coaches and consultants. We want to make sure we're doing things specifically for them. One that we got coming up, and I didn't change the date on this, but next Tuesday, we've got this same webinar coming at you on Google at this basically the same time at 12 o'clock next Tuesday instead of that October date. Then we got.
Todd, I don't see the slides advancing. Is it just me?
Are they advancing?
They look like they're advancing on my end.
Okay.
Here's one we got today. I meant to change that one out, but that's us. And then we have a lot of stuff going on in November. As you can see, we've got these are all the ones that are through our system office, so you can take advantage of all these different webinars and seminars coming up. I also like to remind folks, I keep forgetting to put this in the slides, is that we're on all the socials. I just took a screenshot of our Instagram. I don't know why people can't see the slides. Has everybody seen the slides?
Yes.
I had to hit sync to presenter. I'm not sure why, but then I was able to see your slides advancing.
Uh-oh. Well, we're almost done. Here's the real presenter, Ryan Breen with Breen Law out of Wilson, North Carolina. I like to make sure we give him all his accolades as a super lawyer, whatever that means. Give him his props. And I will stop my share now so that he can pull up his, because that's what you came for today, is his stuff, not my stuff. So, Ryan, let's see.
Hey everybody.
And that's the fun. All right, so you just pick screen, so now there we go.
I'm
All
there.
right.
I'm with
There
you.
we go. Awesome.
Good afternoon, everybody. My name is Ryan Breen. Today we're going to talk about the legal liability of consulting. My presentation is pulled up to take up the entire screen. So in addition to listening to the melodious sound of my voice, Todd will also be in charge of feeding me questions during this presentation. This is going to be a very broad overview of incorporation or organization, contracts, advertising, and agency. Why are we covering 4 topics in one thing? And it's really because legal liability comes at you like a rolling ball of butcher knives. It comes from every direction, every which way they can. If somebody feels wronged, they're gonna come after you. Also, this presentation, and I'm going to quote Churchill, so don't come for me. You can come for Churchill. But this presentation is going to be like any good speech. It's going to be like a woman's skirt, long enough to cover the subject, but short enough to create some interest. So what gives me the right to talk to you all? I've been a general litigation attorney for the last 14 years. What that means very broadly is that I get paid to say words for money. The last 5 years, I've been focusing on criminal defense and small business formation and support. I've been named to the Super Lawyer Rising Star list for the last 5 years in a row. What that means is that I'm in the top 2.5% of criminal defense attorneys in the state of North Carolina. Over the last 2 years, I have served as an adjunct professor at Barton College teaching business law and ethics. And I think I've been providing these seminars for the SBC over the last 7 years. So my time, much like your time, to quote Lincoln, a lawyer's time, a consultant's time, and advice, that is your stock and trade. And when we think about stock and trade and what we're doing, we start to think about corporations. You have a couple of options. You can either incorporate, that means you start a corporation complete with tradable or sellable shares, or you can organize, which means you start a limited liability company or an LLC. No matter what you do, it's important to get that done because it defines your business as legally separate from yourself. It also creates what we call a corporate veil, and we'll go into the corporate veil a little bit more in depth shortly. Um, it allows for transferability of ownership and assets. Hopefully, you do very well consulting. You build up a big brand, and some young whippersnapper up and comer one day wants to buy your client list and figure out what it is you do exactly and what your secret sauce is, and you can make them pay a pretty penny for it. It also protects your own good name. You have the ability to, what the name of your corporation or your LLC essentially becomes your brand, and you can protect your brand and make sure nobody else, at least in the state of North Carolina, is using it. Also, another reason to incorporate or organize is that as if you need to raise capital fast and you need to go the route of engaging a financial institution to do that, you'll have more access to a lender using your corporate name or business name than trying to do it individually. And lastly, it enhances your business credibility. I'll tell you a quick story. A friend of mine was getting married in the Wake County area. She hired a wedding consultant, and it had a big fancy title. It was something something LLC, Magical Memories LLC, or some nonsense. And unfortunately, that person had the terrible misfortune of consulting on a wedding for a pile of attorneys. So if you have a bunch of attorneys who are sitting around and waiting for something to happen, and the bar's not open yet, we'll start looking stuff up. And we all discovered uh, that she was not, in fact, organized as an LLC, and we all immediately started to it immediately started to cast doubt on her ability to function and appropriately pull off this wedding, which isn't exactly what the groom wanted to hear, wanted to be a part of on the day of his wedding, but such is life. Um, S corps, don't ask me about S corp designation. It doesn't matter if you're incorporated or if you're organized. There are certain rules and criteria you have to meet. Whether you're incorporated or organized, you still have the ability to get an S corp designation. That's an IRS designation. Um, and if you're a closely held corporation or a single member or on the low end of a multi-member LLC, you can file for that S corp designation. So we talked about creation of the corporate veil. In the bottom right-hand corner, that's a picture of the steel curtain, functionally impenetrable defensive line. But every once in a while, something snuck through. But a corporate veil is the biggest reason for incorporating or organizing, and that's because, like I said a second ago, it creates that new corporate entity. More important, it creates a separate insurable entity. And it also, because it has its own assets, or should have its own assets, it protects your own personal assets. So ideally, once you a create a corporate organization of some kind, it'll have its own business accounts, it'll have its own property, it'll have its own assets. And you'll hear me repeat several phrases during the course of this presentation. And one of those things is get insurance. Part of the reason you do that is if something no good, terrible, very bad happens during the scope of the performance of your duties that is covered by your insurance. If something bad happens, your insurance company has a duty to come step up and defend you in the event of any kind of litigation, but also they got a bigger pot of money than you got, and have the ability to pay out any claims if they're covered by your insurance policy. So make sure no matter what you do, if you're consulting, coaching, selling shoes on the side of the road, if you've got the ability to get insurance, go get insurance. Like I said a second ago when I gave my brief example, don't about not claiming to be incorporated or organized, you'll absolutely look silly. Hopefully, you're dealing with other professionals and other learned folks, so you need to conduct yourself as a professional. So we'll go into our first or our second topic, which is contracts. Contracts are what establish the relationships between you and your clientele. They outline the duties and the responsibilities of the parties. I'm going to break it down from the beginning and talk about what a contract is. A contract consists of three parts. It is an agreement to provide a good or service for valuable consideration. Agreements are comprised of two separate parts. The first is an offer, and the second is acceptance. An offer is exactly what it sounds like. It's a promise to do or refrain from doing something. And then the acceptance is an unambiguous declaration of assent to the offer, which is a big, long way of saying you are accepting the offer exactly as it was given to you. If you don't accept the offer exactly as it's given to you, it's a counter offer. And that counter offer has to be accepted exactly. And if it's not, you're still negotiating. And it'll go back and forth until you guys agree on exactly what the terms of the contract are. In order for there to be an agreement, there has to be a meeting of the minds, which means both parties understand essentially what's going on in the contract. If there's no agreement or meeting of the minds, it's no good. There is no contract. All right. If you had buzzers, I'd ask you to get your buzzers ready, but nobody has buzzers because this is Teams. But we're going to have a little quiz. Just answer to yourself. Ben Brandt shows up on your doorstep. He says, I'll mow your grass for $40. You agree. He mows your grass. Is there an agreement? The answer to that question is yes. There was an offer. There was an acceptance. We're good. Round two. Ben Brandt shows up on your doorstep, says he'll mow your grass for $40. You say you think it's more of a $20 job. He says, okay, and starts mowing your grass. Is there an agreement? There was an offer. It was followed by, there was no outward acceptance, or there was an offer. There was no acceptance of that offer. A counter offer was made, and that counter offer was subsequently accepted. We know that it was accepted because he began performance. So, yes, there was an agreement. Round three. Ben Brandt offers to mow your grass for $40. You agree. Ben Brandt mows your grass and power washes your driveway. You receive an invoice for $140. Is there an agreement? No. There was no explicit agreement for Ben Brandt to perform that work being power washing. However, if you're watching Ben Brandt start power washing your driveway and you don't stop him or ask what's going on or ask why he's doing that, uh, in the context of a court, that could be considered what's called a quasi-contract, and you could be liable for the cost of the service he provided and you ultimately accepted. Now we'll go back to a regularly scheduled program. The second element of a contract is to provide a good or service. This is you. This is what you do. These are the service part, the consulting or the coaching. That's a service. Goods are things you can touch, feel, and use. The last element is for valuable consideration, which again, I don't know why lawyers use this multisyllabic, highfalutin language, but that's what we're stuck with. So that's what you're getting. Valuable consideration is something of value promised in exchange for that specific action or non-action. Consideration is what distinguishes a contract from a gift. So let's go a little bit more in depth with consideration. Mr. Brandt calls Knox to provide security for his business. Knox agrees to provide security as long as he's paid half before the start date and the remainder after the job completed. Mr. Brandt does not send the first payment. Is there a contract? We've got an offer. We've got an acceptance to provide a good or service. Is there a contract? The answer is no. The contract fails due to lack of consideration. Because that first payment wasn't made and no exchange occurred, there is no consideration, there is no contract. Mr. Brandt has no expectation that Knox can show up and provide security for him. And we're back to our program. It is not a requirement generally for a contract to be in writing, but it is the best practice for every single one of the contracts you execute between yourself and your clients to be reduced to writing. That means the formalization of an agreement between you and your client executed before you start any service. At a minimum, any contract you execute should include time. That includes, date, start date, stop date, a scope of what you're consulting for. And by scope, I mean what kind of service you're actually providing and why you are providing that service, and any type of applicable law, regulation, or professional standard that will be utilized while you try to execute those duties. And most importantly, how and when you get paid. But that's the minimum standard. I want you to be clever consultants. I want you to be smart consultants. So in your contracts, the clever consultant will have language that limits liability for the implementation of practices that are going to be suggested, language that actually defines the applicable law, language that defines a venue for any action for breach of contract or any damages that arise during the performance of your duties, language that protects your work product, and language that creates clearly defined damages if you are not paid on time. So let's talk about language that limits liability. Sample language and what that could look like is, again, this is a high dollar fancy lawyer words. The parties covenant and agree that services or recommendations provided during the term of service have been made subject to all applicable state and local laws, all applicable regulations in accordance with all common industry practice, and based on the information provided by the client during the course of assessing the business. That is important because you only know what you know. If your advice turns out to be bad or not fruitful, you could be liable. But what you want to be able to point back to is your client not providing the information that you would have needed or would have been standard information to receive during the course of your consultancy. Other reasons how that limits your liability, you can't suggest them do anything illegal. You can't suggest they do anything outside of the commonplace industry standard. And like I said, you want that information available so you can point back and say, hey, my information was based on what you provided me. Had you provided me X, Y, and Z information, I would not have provided that same recommendation to you. Another example that should be tucked into a contract between you and your clientele would be that the client understands and acknowledges that all recommendations made are made based on current market conditions, availability of product, and resources of the client. How does that limit your liability? If your changes are implemented or they follow your advice and there's some sort of unanticipated change in an industry condition, your client is on notice that those industry conditions are not your fault. So, for example, if you suggest that if they're getting shipments in from Europe and you decide to advise them for whatever reason that rather than use air shipments to transfer everything to cargo and container ships, and all of a sudden Pirates of the Caribbean 6, which may or may not be coming out, comes out and their cargo ships are just ravaged, they can't hold you liable for that unanticipated change in an industry condition, unless, of course, you were somehow in league with the pirates. You also need language that identifies the applicable law. You don't know what you don't know. And I say that because states have different laws. Federal applicability of federal laws is relatively uniform. However, you don't want to be held to a legal standard that you are unfamiliar with. An example of language that identifies applicable law would be This agreement is made subject to the laws of the state of North Carolina. If any of you have executed a lease or a purchase agreement in this state, if you bought a home, I guarantee you that language is tucked somewhere within that purchase agreement or that contract of purchase. You also want to throw in language that defines a venue for disputes. What a venue is where you would go to address the harms and the wrongs. Technically, you could be pulled into a court if there is no language like this. You can be pulled into a court anywhere your client is transacting business, depending on the scope of the work you provided. So if your client operates several different locations across the state of North Carolina, um, let's say you're dealing with somebody out of the Wake office, however, they're headquartered in Charlotte, they could file a claim against you in Mecklenburg County, and you'd be required to go truck up to Mecklenburg County and defend that claim. So it's important that a venue be agreed upon so you're not sued in an area that it's inconvenient for you and you're otherwise unable to get to. Language like that would essentially look like the parties agree that the venue for any dispute arising from this agreement shall be in the general courts of justice in Wake County. I like to use the general courts of justice in all the contracts that I write, review, and recommend to my clients. Sometimes, especially if you're dealing with a larger corporation, they will tuck in an arbitration clause. I hate an arbitration clause. It is slightly more efficient, but it is infinitely more expensive. Part of the reason larger corporations prefer arbitration clauses is because they have essentially they pick an arbitrator and they constantly do business with that arbitration group. And I can't say one way or the other whether or not they get preferential treatment, but it certainly feels like that way. And usually you're on the hook to pay at least half the cost of arbitration. Um, and that is more expensive than filing suit in the general courts of justice. But whatever you decide is really up to you and the client. The other type of language that you need to,
Hey,
yes?
Ryan, there's a question
Okay.
regarding contract language. What if the coach consultant is based in North Carolina, but the client served is based in another state? Shall the language just align to the consultant's location? Example, North Carolina.
I would I would advise that the language included say that the contract, because it's where the contract is made, where the contract originates from, that it is being made pursuant to all the laws of the state of North Carolina, not the other state. Because otherwise, like I said, you don't want to be on the hook for any other state. You don't know what the laws of Delaware are like. You don't know what the laws of Virginia are like. Whatever counsel you hire, you know you want the advantage of being able to have local counsel. And if there is language within that agreement that stipulates some other jurisdiction, ethically, you're going to have to find a lawyer who practices in that jurisdiction in order to assist you with that contract. Me personally, when people bring contracts for me to review, or they bring contracts that they want advice on or assistance with in drafting, if it originates from a state that is not North Carolina, ethically, I tell them I cannot help them because I do not know the laws of that other state, even if they are similar to those of the state of North Carolina. Um, I send them out the door. I think it would be easier for you. Maybe not so much easy on your client, but definitely easier for you if the agreement was made subject to the laws of the state of North Carolina. I'm sorry, y'all. I just came back from Disney and I think I picked up something from that cesspool that is Orlando and or the airport in Orlando. But you also need in your contracts to tuck in language that protects your work product. And that's because your secret sauce is you. When you're consulting or coaching or whatever, your methodology is your own. You are really selling yourself, your time, your knowledge. Your vendor list and any outside sources you use are your own, and it's important to protect your methodology. So I would, depending on the type of consultant work you are doing, I would toss in language that could include that the consultant agrees to provide to the client the findings of the report, the factors utilized in formulating their conclusions, and that the client understands and agrees that the analysis provided is work product to which the client is not entitled. It's sort of like taking a multiple multiple choice math test. What's important, or what typically is important to your clients, is the answer. You don't necessarily have to show them your work. And your work is what really needs to be protected, because the next time they run into an issue, a similar issue, depending on how much you're willing to reveal or divulge, it could be reverse engineered, and then you've lost business. So if you have a specific methodology you use in whatever consulting business that you have, make sure you keep that to yourself as much as possible. Getting paid is important. So you need to make sure that there's language in your contract that clearly defines what happens if you don't get paid on time. Sometimes clients forget to pay or decide that arbitrarily that your work doesn't warrant any kind of payment. That's not their decision. It comes up to the contract. If you put in work, if you put in time, you're not giving it away for free. You need to be compensated for your time. So sample language that clearly defines damages if not paid in time could look like: the parties covenant and agree that payment in full shall be tendered within 10 days of consultant tendering its report. In the event client desires additional findings or analysis not contained within the original scope of this agreement, the parties shall execute a new agreement. And also in that same area, you can include language regarding late fees or interest, or, if you have to file an action in order to get payment due under the contract, that the other party has to pay attorney fees. In North Carolina, that has to be explicitly stated in the contract. So if your contract does not say that, if it does not say explicitly that the prevailing party is entitled to attorney fees and costs, when you get to court, you're not going to be able to get those attorney fees and the cost of court. Just a brief note on oral agreements. They're generally enforceable as long as the three elements of contract are satisfied. So again, an agreement to provide a good or service for valuable consideration. But like I said, we're clever consultants. Clever consultants don't use oral agreements. Clever consultants write contracts. Just a helpful hint: document everything. What exactly does that look like? So if you got text messages between you and your client prior to formation or during the course of your business with that client, screenshot and print them. If you exchange emails, save and print them. Conversations, depending on what you do, take real-time notes, or you could even record your conversation. North Carolina is a single party consent state, so that means unless there is something in your contract that precludes you from recording them, you absolutely can. Now we're going to shift over to advertising. I get it. Everybody in here is awesome. You are the best at what you do. I am super proud of you, but you absolutely do not and should not guarantee any kind of results. Guaranteeing results creates an additional term to your contract, even though it's not explicitly expressed in the contract, and that's called a warranty. A warranty can be expressed or implied, and it's a promise or assurance of some kind. If you do not deliver the results advertised, then you absolutely can be held liable for not delivering those results. Just by way of a personal example, I handle approximately 300 speeding tickets a year. Over the course of my career, that's about 4,200. Of those 4,200, I personally cannot recollect one that resulted in my client getting insurance points or resolving it in such a way where their insurance went up. However, notwithstanding 4,200 experience dealing with 4,200 speeding tickets or so, I cannot guarantee my clients that they will not receive license or insurance points. And why is that? Because number 4201 may result in points. And if they represented to the state bar, or they told the state bar that I guaranteed a result that would not result in any kind of license or insurance points, I could lose my law license. So be very careful and very mindful when you talk about what kind of results you can provide as a result of your coaching or consulting. So, what do I say instead? I say things like, if the information you provided me is accurate, based on similar tickets I have resolved, I can resolve your ticket in such a way where you will not receive any license or insurance points. That gives some equivocation as to what the result could be. Oftentimes, one of the biggest barriers in handling a speeding ticket, and again, this is just a personal experience that it can be relatable, but one of the biggest issues is if the client, in their interaction with the police officer, decided that they were going to exchange heated words with the police officer. And the police officer, the copy of the ticket that the client gets or the defendant gets does not have these notes, but the court copy absolutely does. And if you pop off at the mouth and you say no good, terrible, very bad things to the police officer, oftentimes they will put that in the officer notes or comments, which makes it exceedingly difficult uh, to get a ticket resolved in the way that you would want to get it resolved. Or sometimes I say that based on the information provided, I should be able to resolve your ticket in such a way that license or insurance points will be mitigated. Mitigated means less. Less can include zero or none. Either way, that's sort of what I tell my clients in regards to soliciting business from them, or when I talk to them and explain to them the consequences of my representation of them in the context of a speeding ticket. So what does that mean for you? Because to be sure, we're not sitting around here. I'm not sitting around here talking to a bunch of lawyers. Um, but you don't want to create any kind of express warranties by guaranteeing a result. If you do, there are consequences. Like I said, liability when you're operating a small business of any kind is like a rolling ball of butcher knives. You may be subject to claims of breach of contract, fraud, or unfair and deceptive trade practices. And just like how they sound those are bad. Those are bad claims, and that's a headache that you don't want to have to deal with. While we're on the subject of warranties, it's also very important to note that there are implied warranties that come along with your work. An implied warranty is is contained in any kind of work that is provided for a client. An implied warranty or sale of good. An implied warranty protects a consumer even when a warranty isn't explicitly stated. Just very briefly, the implied warranties that could apply to consultants, fitness for a particular purpose. So if you were generating a report um, and it did not comport with what the client needed, that would be a breach of the implied warranty of fitness for a particular purpose. And warranty of workmanlike performance, that means that you do your duties in compliance with any and all industry standards, or as a similarly situated consultant or coach would. If you breach either one of those implied warranties, you could be held liable for that breach. Now we're going to shift into the last portion.
Can
Which is-
we answer another question before you shift, Ryan?
Absolutely.
All right. So Lauren asks, can you have a clause in your contract that states something like, if clients request significant modifications to these terms and conditions, an additional fee of XYZ, attorney fee for reviewing new contract will be charged to the client?
Absolutely, but I think you have to list in the contract what those potential attorney fees would be. I don't think you could just blanketly say attorney fees associated with modification of the contract. Um, just like there are cars on the road, and just like there is liquor at the store, and just like there is cereal at the grocery store. Um, there are different levels and different price points for that fit every budget. And I think you would get significant pushback if, let's say, you know, I was, I'll tell you this to say, or so I was helping somebody file a lawsuit in Mecklenburg County. Um, District court, cause of action, breach of contract. I tried to send them to somebody out west. They were going to charge $10,000. For a similar lawsuit in Little Old Wilson, I would have charged 750 plus costs. Um, I think it's important to share with that client um, what that price point would be. And certainly if I was on the other side of that and I was on that client's legal team, I would have not to exceed language contained, or I would insist on not to exceed language being placed in that contract before my client signed it in regards to modifications of the contract. Um, I just think it's better practice for there to be a cap so that that way you're not, because hiring an attorney is something you should do if you've got questions, if you need assistance. Um, but it's not anything that anyone is necessarily obligated to do. So let's say in that same hypothetical example between the 750 and the 10,000, it's both work has to be performed functionally the same way. The time is going to be functionally the same. Um, but if a client gets hit with a bill for $10,000 instead of 750 based on how this attorney values their time, I think you're going to end up with more problems. So I would make sure that any kind of language that talks about the attorney fees associated with modifications, um, if you're going to put an attorney fee clause in there, then there needs to be a cap, or they need to have an idea of what exactly it is they're signing up for. Does that long, rambly answer your question?
Lauren, can you unmute? Or, okay, fantastic.
All right. So we're gonna slide over to agency. An agent is a person that has or appears to be acting under the authority of the principal. A principal is usually the owner or the employer, and it typically arises from an employee-employer relationship. Um, just a brief note, we talked about contracts. When you execute a contract with a corporation, company, etc., anything that has any kind of bureaucracy to it, you need to make sure that the contract that you are executing is actually signed and executed by someone with the authority to actually execute that contract. If Bill from the mailroom pops up there and signs the contract, that's not good enough. That's not going to be enough to bind the contract to the terms and conditions of that. You need to make sure that whoever is signing that is some kind of manager or vice president and otherwise has the ability to uh, bind your client to the terms and conditions of your contract. There are two main different kinds of employment. There are two main types, uh, employer, employee, and independent contractors. The difference between the two comes down to control. The questions that are typically asked by the court are whether or not the employer has the right to control how, when, and what the worker does. Does the employer control the materials used and whether expenses are reimbursed? And does the employer provide other benefits other than regular compensation? Things like insurance, vacation, retirement, dental, vision, etc. So I don't know how old any of you are, but if you are if you are somewhere between 25 and 40, you may have picked up that I'm showing you pictures from the movie Roadhouse. And why am I doing that? First and foremost, it's possibly the single greatest movie ever made. And second, to me, as I've done this and explained this over the course of several years, I think it's the easiest way to explain agency. And actually, I utilize this in almost all my classes. Um, Roadhouse is an example of how to conduct and execute a business, what to do, what not to do. But today we're only going to focus on the concept of agency. So, if you haven't seen that movie, and I strongly suggest you do, you'll be a better consultant for it. In the movie, there's a main character. His name's Dalton. He's played by Patrick Swayze. He is bouncing at a nightclub, and he's approached by a business owner named Tillman. Tillman owns this nightclub called the Double Deuce, and the Double Deuce is an absolute nightmare. There are fights, drugs, embezzlement. I think he describes it as it's a bloodbath every night. And Dalton is known as the best cooler in the area, so he's the best head bouncer, best security guy in the area. Even though, if you've seen the movie, even Dalton will agree Wade Garrett is the best cooler, but he's getting kind of old. In the movie, Tillman's only directive is that Dalton clean up the Double Deuce. For that, he provides some cash up front and cash to him nightly. Dalton tells him he'll get there when he gets there. When he finally arrives, Tillman tells the staff just to listen to Dalton, and what he says goes. So, is Dalton, in that context, an employee? No. Much like you, Dalton is an independent contractor. Tillman does not control his methods, he does not control his hours, and provides no other benefits other than the upfront costs and nightly compensation. What Dalton does is he goes and he provides suggestions on who should be there, who shouldn't be there, what they need to do in order to run the business more effectively and efficiently. Essentially, Dalton, who is a bouncer, is a small business consultant. By way of contrast, let's meet Carrie. Even though she introduces herself as Carrie Ann, when you look at the cast, she's listed only as Carrie. One could presume that Ann is her last name, but that would be silly. But it was the 80s, so her last name could be Carrie Ann. But Carrie Ann works a set shift as a waitress. She only carries out her own duties, so she only takes food and drink to and from the bar to the patrons. Even though it's not explicitly stated, she gets her wage plus tips. So is Carrie an employee in this context? Yes. And why is that? Control. The control that Tillman has. So what does that mean for Tillman? Tillman is liable for all the actions of Carrie while she is acting within the scope of her employment. However, Tillman is not necessarily liable for the actions of Dalton while he is acting within the scope of his independent contract. So just again, to go back to the movie, during the course of Roadhouse, Dalton gets into several fights. He doesn't start, which end up causing a lot of property damage and personal injury. Would Tillman be liable in that context? No, as long as Dalton did not initiate the physical confrontation. It is important to note that, let's say you are running a security business or a security consulting business that requires a more hands-on approach to things. If you are acting in furtherance of the business and you do not provoke the altercation, then the person who hired the independent contractor could be held liable. But in this very limited context that appears on the screen, Tillman would not be liable necessarily for the actions of Dalton. But during one of the fight scenes in the movie, Carrie hits a patron from behind over the head with a bottle. Would Tillman be held liable? And the answer to that question is yes, and that's because that employee believes they're acting in furtherance of the business of the Double Deuce, which Tillman owns. So Tillman would be responsible for the actions and damages caused by Carrie, not responsible for the damages and injuries caused by Dalton. But more pointedly, as this relates to you, if you are an employer, if things are going right, if this consultant business is going gangbusters and you've got underlings, you are liable for the actions of that employee while they act within the scope of their employment. or while they're acting under the authority of their employment. Implicit in that, and I'm sorry, I'm fighting to sneeze, is that as an employer, you have a duty to supervise your employees and make sure they are carrying out their duties in a workmanlike manner. Um, and I tell you that to tell you this, I know this isn't the accounting group, but there have been an influx of employer liability cases where fraud is alleged to have been committed by an employee, and it's a position where the employer knew or should have known that the employee was committing fraud. So no matter what kind of consulting or coaching you are providing, if you have employees, you need to make sure you are keeping an eye on your employees. So getting towards the end, um, and as you can see from the slide, avoid is in quotation marks because there's truly no way to absolutely avoid liability. The best you can do is try to mitigate the likelihood of any kind of liability and try to stop problems before they start. So, just to recap, one of the best ways is to make sure you are operating under a corporate structure of some time. Once you get operating under that corporate structure, go get insurance. When you're dealing with a client and you're setting up your services, make sure you reduce all of your contracts to writing and you document all of your transactions between yourself and your client. You need to make sure that you're not making guarantees in advertising or during the solicitation of business. Remember, that could create an express warranty in addition to the implied warranties that already exist. And even though that express warranty is not necessarily tucked into the contract, if that guarantee was made and it was part of the inducement of them entering into that contract, so if they come to you because you guarantee that profits will increase 500%, even though it is not in the contract, and even though that's just an advertisement, you can still be held liable for fraud because that's fraud in the inducement. And also, you need to make sure that you are keeping an eye on your employees if you have employees. You need to make sure when you're in your discussions with your employees that you have a clear set of expectations for them and that those expectations are known. If you've got questions, put them in the chat. I'll exit out of the presentation shortly and start working through them if you've got them. And then lastly, I like to end with a disclaimer. Please note that the foregoing has been a presentation for educational purposes only. Any kind of questions I answer, that does not create any kind of attorney-client relationship. If you want to hire me, you absolutely can. There's my website below. And if you have any questions, you are specifically advised to direct any of those specific questions to a licensed attorney. See what I did there? You can't put me on the hook for anything I said during the course of this presentation.
All
Ryan, you got it.
right, so there are questions. So
All right.
regarding insurance, are there suggest insurance levels when a client is an individual versus client is an organization? And is there a general practice on how much insurance is reasonable in those instances?
I think it depends on what specifically you are consulting for and who your clientele is. If you are like let's say you are a factory consultant or an engineering consultant and you are going into factories dealing with multi-million-dollar machines, you need to have a policy that could cover multi-million-dollar boo-boos. Um, if you are, a health and fitness consultant and something you suggest results in an injury to your client, you don't necessarily need the multi-million-dollar policy. What my general rule is that you need to have enough coverage that if the limits of the policy need to be reached, that they won't reach any farther but beyond the limits of that policy. So me personally, I think because essentially all lawyers are consultants that do practical application on behalf of clients occasionally. Um, but my personal liability policy is $300,000. And that's because I make it a point not to take any cases that are overly complex or deal or could potentially deal with amounts in controversy over that. So the rule or the general practice on how much insurance is reasonable, it depends on what what your line of work is. The next question is, are interns considered employees? They are not getting paid. However, they are there for an educational purpose. Um, or the argument would be that they're there for an educational purpose. That educational purpose would be the consideration they are receiving. Interns probably need to be more closely supervised than regular employees. Um, I would contend that an intern for a company would should be considered an employee and respondent superior, which is the fun Latin phrase of saying of let the master answer. That's the legal terminology that essentially puts employers on the hook for liability for their underlings, um, because they are essentially and should be operating under that higher standard of care. Um, that would any actions that they provide would give liability to the employer. So in the context that we're discussing in liability, interns would be considered employees. Any other questions?
So
Got
there's
another
a
one.
question. Okay, go ahead, Todd. Sorry.
Do you recommend having a trust or other type of estate planning to further protect personal assets, or is an LLC, PLLC enough?
So that that would definitely depend on the amount of your assets. And I'm sorry again that I'm stuffy, but I think as far as separating yourself from your business, my general advice would be creation of a corporate entity would be sufficient to protect your corporate assets. In addition to whatever the assets the corporation has, any kind of insurance policy they have, that should be sufficient to or you maintain should be sufficient to protect your personal assets. The other thing to be mindful of is that let's say you are a a one person show. You're the only employee of your organization. Um, what you have to be able to demonstrate is that your business is separate and apart from you. So I would not run a pile of personal expenses through your business. Um, the more you do that, the easier it is for people to pierce the corporate veil. And if somebody can demonstrate that the way you transact business, the corporate structure is just a mere instrumentality of yourself, essentially just a paper corporation. There is no difference. If they can demonstrate that, they can pierce the corporate veil and potentially come after your corporate assets. So you need to make sure in your own practices, as far as buying things, purchasing things, that whatever personal expenses that you may incur during the operation of your LLC, you try to keep or your business, you try to keep them as separate as possible. As far as establishment of a trust or anything like that, you really need to talk to a financial planner, um, or a tax attorney regarding the ramifications of transferring personal assets into a trust.
All right, we got just a couple more minutes left. Any other questions? Really great questions.
I would be interested to know what kind of consulting and or coaching some of you do if you feel comfortable sharing. I love a good uncomfortable silence.
So there's a comment, an empowerment coach, engineering, drafting as a sub-consultant to other civil surveying firms.
Okay.
There's a widow life coach, executive coaching, supply chain consultant, a biotech program management.
Okay.
Do you see these, Ryan?
I don't see any of them.
Oh, okay.
but
Consulting for education, organizations and corporations for organizational transformation.
Mhm.
That's the
but
last one.
sort of going back to the question regarding insurance and suggested insurance levels. We can just, and I'm not putting anybody down, but I think we can all agree that there's a disparity between biotech and in empowerment and or assisting widows. The biotech consultant probably needs to maintain a higher insurance policy than the widow or the empowerment coach. Does that make sense? I'll refresh the chat.
You got a thumbs up. Yeah.
Okay. But I think those are all, I mean, that's a broad swath of coaching and consulting.
Which is also why when you go for insurance that there'll be different levels, right? Because
Yeah.
different levels of liability, just like anything else.
Absolutely.
All right. Last call for questions. Any others? Appreciate everybody. We'll have this one recorded. If you missed it last week, we had access to a CPA. And it was designed for coaches and consultants as well. So if you missed that, the recording is up on our website. You can register to catch that one if you missed it. Otherwise, we'll put this one out the same way for folks who missed it. We know we had a lot of interest in folks that had registered for this one. So Ryan, appreciate it.
My
Really,
pleasure.
appreciate all the good info. That's always good for everybody, no matter what they're doing, to make sure they cover their butt, if you will, right? In terms of what they're doing. Um, all right. No other questions? Last call. All right. Thanks, Ryan. See you next
Thank
time.
you. Bye.
Thank you, Ryan.